Justice Danladi Umar-led CCT had in June last year terminated the trial upon an application by Saraki by dismissing the entire 18-count preferred against the Senate President in a no-case submission ruling. The CCT's decision was based on the grounds that the prosecution, with its 4 witnesses and 49 exhibits, tendered only led hearsay evidence, which could not be the basis to link Saraki to the 18-count preferred against him. However, the Court of Appeal in Abuja ruling on December 12, 2017, in an appeal filed by the federal government against the decision of the CCT, restored 3 out of the dismissed 18 counts and ordered Saraki to return to the CCT for continuation of trial. While Saraki had appealed to the Supreme Court against the part of the Court of Appeal's decision restoring 3 of the 18 counts, the federal government had cross-appealed against the part of the decision affirming the tribunal's dismissal of the rest of the 15 counts. However, in its lead judgment on Friday, Justice Sentus Nweze upholds Saraki's appeal and dismissed the federal government's appeal. Justice Nweze agreed with the CCT that the evidence led by the prosecution at the tribunal was entirely hearsay. He says that the Court of Appeal was wrong to have restored 3 out of the 18 counts earlier dismissed by the CCT, when it agreed that the evidence led by the prosecution was hearsay, but went ahead to isolate 3 of the count as having been proved. After the judgment, counsel to Saraki, Kanu Agabi, SAN, says it is a victory for democracy.
I just want to say that we are grateful to God. We are grateful to the Supreme Court. This matter is over. Let there be peace in our country.
The almost 3 years legal tussle between the federal government and the Senate President, Bukola Saraki, has eventually come to an end, with the Senate President being a victor. Joseph Kadri, ITV News, Abuja.